Martha.
Thanks so much. Uh, thanks so much, Anthony and Sophia, and the rest of the collaborators who have worked on the tort law and social equality project. I want you to know that when I saw the launching of the project, I thought, yes, Canada. And those of us in the United States are envious. And we are very glad that you're going global with this speaker series. So before I start my talk on trauma damages, I thought maybe I would start with a little confession. That's always good. I've spent a great deal of my career writing about emotional distress, sexual abuse and damages. But I have to confess, I've always felt a little uneasy relying too heavily on the construct of trauma or using the rhetoric of trauma. I think it actually has something to do with aligning early on, primarily with dominance feminism and the philosophy of Catherine McKinnon. I just felt more comfortable talking about oppression and discrimination rather than trauma and recovery. But as I think you'll be able to tell, I'm sort of slowly changing my tune. The more I read about and learn about trauma, the more admiration I have gained for the importance of the construct in healthcare, in culture, and maybe even tort law. So, as you know, the trauma as a concept is ubiquitous. One writer has gone so far as to call it a defining characteristic of our times. Its ascendancy is so pronounced that law schools have taken notice, and students are now being taught trauma-informed approaches to the practice of law. Trauma, of course, has been increasingly used to describe injuries that are disproportionately experienced by marginalized groups, as in race trauma, racial trauma, or trauma to individuals giving birth, which I'm going to be calling birth trauma. But historically, trauma, of course, has had a broader application. And it's been used to describe the experiences of combat soldiers, accident victims, victims of natural disasters, and others who are subjected to horrific situations. Now, you would think that trauma would have everything to do with tort law. Many tort victims are traumatized by events caused by tortious behavior, and many others would seem to qualify as the classic eggshell plaintiffs who suffer intensified injuries because they've experienced trauma in the past. Trauma comes into play with respect to at least two legal issues. First, determining the type of injury suffered by the plaintiff, particularly whether we characterize the injury as physical or emotional. And second, determining the severity of the injury, including the amount of damages. As someone who approaches tort law from a social justice perspective, it also seems clear to me that trauma has a special relevance to systemic injustice. It pushes against the devaluation of injuries of marginalized groups. Many contemporary social justice movements, including the Me Too movement, the Black Lives Matter movement, reproductive justice movement, rely on the rhetoric and the logic of emotional trauma. The social justice dimension of trauma was recently underscored by Dr. Judith Herman and her new book, Truth and Repair. She's the psychiatrist who first popularized the concept of trauma for rape victims. For Herman, trauma is not only a matter of individual psychology, but also always of social justice. The social justice frame is important and appropriate because, in Herman's words, the violence at the source of trauma aims at domination and oppression. And to recognize trauma, to even name it, requires historical context of broad social movements of human rights. She views trauma as an affliction of the powerless. So everything comes in threes, and my remarks today are going to be in three parts. First, I'm going to talk a little about the history of trauma as a construct, and then specifically about PTSD. Then I'm going to look at three contexts in which trauma affects marginalized groups: rape trauma, racial trauma, and birth trauma. And then, of course, I had to come up with three lessons for tort law, and I'll end with that. So when we think about trauma, the first association most of us make is to PTSD, the diagnosis of post-traumatic stress disorder. Found in that all-important document, the Diagnostic and Statistical Manual of Mental Disorders, the DSM. And the current DSM's definition of PTSD is quite detailed and stringent. I have to say also that when I began to sort of delve into PTSD, it was interesting to me that the DSM is sort of lawyer-friendly in a way. I thought it read like a restatement provision, at least the PTSD provision. Now, to qualify for a PTSD diagnosis, several criteria must be met. Starting with the all-important criteria A, and that is a person's exposure to actual or threatened death, serious injury, or sexual violence. So what's interesting here is this idea of exposure. It's critical. The DSM recognizes that trauma can result not just from being the target of a physical attack, but by witnessing the event or even learning that a relative or close friend has suffered traumatic injury. The DSM goes on to require that to get a diagnosis, the person must experience a variety of mandatory symptoms. The mandatory symptoms are, at least for me, are now kind of familiar, but I realized that they weren't familiar not so very long ago. So the list consists of intrusion symptoms, flashbacks, nightmares. Also, the victim must manifest avoidance symptoms of people, places, conversations, or activities associated with the trauma. There must be documented negative alteration in cognition and mood, such as the inability to remember important details about the trauma, or feelings of detachment or self-blaming. And finally, there has to be alterations of arousal and reactivity, such as irritability, angry outbursts, or hypervigilance. As a psychiatric construct, trauma straddles the line clearly between the physical and the emotional. Although it's found in the Manual of Mental Disorders and it's considered a psychiatric disorder, it is most often anchored in the physically violent events, and it manifests itself in the body. As the author of the best-selling book, and I like the title, "The Body Keeps the Score," puts it, trauma produces actual physiological changes, including a recalibration of the brain's alarm system, an increase in stress hormone activity, an alteration in the system that filters relevant from irrelevant information. I also think, in thinking about PTSD in the law, it's important to recognize that, like legal and cultural concepts, psychiatric concepts are highly contested, and they're affected by the political pressures of the day. One scholar maintains that PTSD as a medical diagnosis was largely the result of negotiations among various institutions and stakeholders, rather than being a pure scientific discovery. So, as a construct, trauma has a long engendered history. Although PTSD is often, I think, for most people, associated with combat trauma, a concept of psychiatric trauma was first used in connection with railway accidents in the mid-19th century to explain nervous shock in what was called railway spine. Nervous disorders sustained by passengers whose immediate physical injuries appeared minimal. This diagnosis of railway spine or nervous shock allowed some plaintiffs initially to get recovery, even though their symptoms, and sometimes those symptoms were miscarriages and stillbirths, developed after the accident. But the railroads soon fought back, and they got medical experts who expressed the view that such injuries were purely psychological, and they were traceable to the nervous temperament of the victims. Many of them were women, often pregnant women, rather than the fault of the railroad. Now, this toggling between internal explanations, pre-existing conditions, and external explanations, traumatic events, would become a familiar refrain, mirroring the larger struggle between dispositional and situational explanations of causation and harm that have been identified by cognitive psychologists. As my early scholarship on fright explained, the move to conceptualize such nervous shock injuries as purely emotional generally had the legal effect of rendering the claims not legally cognizable, given that negligence law generally didn't extend its protection to pure emotional harm. The modern precursor of PTSD arose in World War I under the name of shell shock. It's interesting, the name was based on an assumption that the symptom's primary origin was a neurological injury from a specific event, such as the discharge of an explosive in very close proximity. From the outset, though, this recognition of shell shock was resisted by military and political forces. The official view tended to be that well-trained troops, properly disciplined, would not suffer from the disorder. And a similar pattern also occurred during World War II. Now, interestingly enough, the disorder traveled under the name of traumatic neurosis. You know, Freud was big during that time. And there was a lot of interest. And then after World War II, the academic writing on the subject sort of disappeared in 1947. And then there was Vietnam. In its contemporary incarnation, trauma reemerged in the aftermath of the Vietnam War. After intense lobbying efforts by Vietnam vets, veterans groups, and their family, the PTSD diagnosis was finally adopted in the DSM-3 in 1980. The power and scope of trauma as a concept really expanded when the ascendant feminist movement took up the concept to explain the experiences of survivors of rape, domestic violence, and childhood sexual abuse. Notice it wasn't that there was an epidemic, a new epidemic of intimate violence, but there was this newish vocabulary to push against the invisibility of such injuries. Judith Herman's popular book, Trauma and Recovery, published in 1992, struck a responsive chord. And ultimately, the DSM Criteria A was revised to list sexual violence as one of the qualifying events that can anchor a diagnosis. So some critics have worried that the PTSD diagnosis is too broad and subjective. Others have characterized the diagnosis as too narrow. For quite some time, researchers and clinicians studying the effects of chronic racism in the United States have advocated to reconceive trauma to respond to injuries experienced by African Americans and other racial and ethnic minorities. They point out that many racist incidents are not acts of physical violence, but microaggressions and other kinds of racist behaviors, such as verbal or emotional abuse and resource denial. That accumulate over time and produce symptoms, like those mandatory symptoms, that are very similar to those demonstrated by prototypical trauma victims. However, proposals to amend the DSM to include race-based traumatic stress, RBTS, haven't yet been adopted. One writer laments that modern racism largely remains outside the scope of PTSD. A related controversy surrounding trauma involves what's known as complex PTSD, or developmental trauma disorder. This type of trauma largely affects children who experience violence, abuse, and neglect, especially by caregivers, and has relevance, I think, for concretizing the concept of racial trauma. In many cases, complex trauma involves repeated exposure to or victimization by violence, often coupled with severe environmental deprivation associated with endemic poverty. The basic idea here is that adverse childhood experiences can have enduring negative effects on brain development, produced by dysregulation of stress hormones, leading to problems with attention and concentration, getting along with others, obesity, mood swings, detachment, and self-harm. Before I move on to talk about the three trauma contexts, I do want to stress that given the scientific allure of the PTSD diagnosis, I think it's easy to overemphasize the significance of receiving a diagnosis. While I think the PTSD diagnosis is obviously important, it's not, in my view, the be-all and end-all to understanding trauma. We shouldn't lose sight of the fact that the DSM is designed for the purpose of diagnosing diseases and treating patients, not determining legal liability. I think rather than simply borrowing the concept, we're better off keeping our eyes on the prize, on providing compensation for serious traumatic injuries, whether or not they meet the technical requirements of the DSM. So now I want to turn to three contemporary contexts in which advocates have deployed the language of trauma to underscore the devastating and long-lasting effects of the victim's experience of injury. First, rape trauma. So I think the trauma of rape victims is actually the best known. It's infiltrated many areas of the law, civil as well as criminal. Many rape victims have taken advantage of a PTSD diagnosis to offer expert evidence, not only to prove the severity of their injuries, but to help establish their lack of consent or to explain seemingly inconsistent behavior, like why they didn't report the rape sooner. Although some courts caution juries not to use the PTSD evidence to prove the fact of the traumatic event or to judge the plaintiff's credibility, it seems to be the consensus of the courts to admit PTSD evidence in sexual assault cases, generally with a limiting instruction. including sexual violence, I think, in the DSM's criteria A for PTSD was a crucial step that set the stage for more widespread use of the diagnosis in rape cases. The success of rape victims in using the PTSD diagnosis, not surprisingly, has encouraged advocates to use rape as a kind of template for drawing parallels between rape and other types of trauma. For example, comparing racial trauma to rape trauma. However, the PTSD label maps more easily onto rape cases than it does some other contexts. In the DSM-5, rape qualifies as a singular event from which trauma typically flows, akin to death, threatened death, or other serious bodily injury. In this way, it resembles other singular traumatic events, such as exposure to combat, accidents, or natural disasters that trigger onset of the condition. The PTSD diagnosis thus treats rape like other physical injuries and anchors the diagnosis to the physical realm, even though the symptoms of trauma are a mixture of the physical and psychological. I want to say, though, in one respect, the infiltration of the PTSD diagnosis into civil rape cases has not significantly changed tort law. Jonathan Carty and I have recently written an article called The Negligence Case for Rape. And we learned that not all rape cases are approached by the court in identical ways, even if we think the trauma they cause is the same. For the most part, stranger rape cases are still treated more favorably than date and acquaintance rapes. In date and acquaintance rape cases, where there is most often no evidence of extrinsic force. And what I mean by extrinsic force is no force beyond that what's necessary to affect sexual penetration. When you don't have that kind of evidence of extrinsic force, many courts continue to classify the injury as an emotional harm. This categorization triggers the greater proof requirements for emotional loss if you bring a negligence claim. And interestingly enough, it relegates the plaintiff to arguing sometimes that her rape was an offensive battery as opposed to a physically harmful battery when the claim is litigated as an intentional tort. This categorization minimizes the harm of rape, and at least to me shows that the lesson that rape trauma is some distinctive injury that can't be understood simply as a form of emotional distress has yet to be thoroughly incorporated into tort law. So next, let's consider racial trauma. Perhaps the clearest way to envision the concept of racial trauma directly impacting tort law involves its potential role in intentional infliction of emotional distress cases. As you know, intentional infliction cases are notoriously difficult to prove, requiring that the plaintiff demonstrate that the defendant's conduct was extreme and outrageous, and that they suffered serious or severe emotional distress. In a recent article, Hafsa Mansour examined the case of a 26-year-old Black woman in New Jersey who was subjected to a tirade of racial invectives, including use of the N-word, by the owner of a donut shop when the plaintiff complained that her donut was stale. The outburst took place in front of other customers and greatly upset the plaintiff. But the court dismissed her claim on summary judgment on the basis that she didn't suffer severe emotional distress. Mansour argues that the severe emotional distress standard has a particular propensity to bar recovery in racism cases. Her claim is that many people of color, in response to decades of chronic racism, tend not to manifest their emotional injuries of racial incidents in the right way to enable them to sue because their experiences don't quite match up to the rigid confines of pathological disorders. Mansour's solution is to incorporate the theory of race-based traumatic stress, RBTS, into intentional infliction cases to prove the serious emotional distress element. Now, the main difference between, as I can see it, between PT and RBTS is in the nature of the event that produces the traumatic symptoms. With racist insults, microaggressions, and other discriminatory behaviors, replacing combat or other life-threatening events. This would seem to be a giant difference. But researchers of RBTS say that not every event precipitated by racism produces traumatic stress. For traumatic stress to be present, the triggering event must be experienced as sudden and uncontrollable, but it need not be physical or explicitly tied to a physical event. Mansour's proposal would permit plaintiffs to introduce evidence that their symptoms, think about the mandatory symptoms now, are consistent with RBTS to satisfy the requirement of severe emotional distress. Beyond intentional infliction cases predicated on racist incidents, if race-based traumatic stress was recognized and regarded as a widespread phenomenon, I think it would significantly increase the number of individuals classified as eggshell plaintiffs, people who are vulnerable to suffering intensified injuries if subjected to tortious behavior. Research indicates that past trauma, rather than buffering people, if it doesn't kill you, it makes you stronger, not so, tends to make people more vulnerable and, not surprisingly, exacerbates the effects of future trauma. An analogy would be, and has been, committing a rape of a rape survivor, or shooting at a person who had survived a prior mass shooting, as it recently happened in one of the school shootings in the United States. In each instance, the commission of the tort would compound the pre-existing traumatic injury, and it logically should increase the award of damages. Notice that here that even if the tortious behavior alleged is not explicitly racist, damage awards in cases involving plaintiffs with a background of trauma would reflect the pre-existing effects of chronic racism. This reconceptualization could change the way we estimate chronic potential losses. For example, rather than viewing low-income minority neighborhoods as places where economic losses from tortious conduct are likely to be lower than they would be in more affluent neighborhoods, the calculus would be altered to take into account the increased cost of inflicting harm on persons who are already suffering from traumatic stress. Thus, if a toxic spill or a train derailment occurred in a low-income neighborhood characterized by extreme poverty and violence, the defendant would have to respond to the full cost of the injuries inflicted on the victim suffering from intensified emotional distress due in part to their pre-existing condition. In such cases, the hope is, legal liability might have the effect of making the need for trauma counseling more visible, and in other mental health services more compelling, and increasing the funds for such purposes. Now, admittedly, the move from racial trauma to establish severe emotional distress in an IIED case and using it to transform the tort's remedial landscape through broadened application of the eggshell plaintiff rule is a pretty big leap. The former fits into a conventional account of tort suits as vehicles for rectifying an imbalance between the individual parties caused by the defendant's tortious behavior, while the latter, eggshell plaintiff context, plugs into social systems of racism and social inequality and seems aimed at broader social goals. Thus, a proponent of corrective justice or civil recourse theory might have little difficulty endorsing the use of an RBTS diagnosis to prove severe emotional distress in an intentional affliction case, but they may balk at attempts to augment recoveries for larger populations of torts plaintiffs whose prior experiences of violence and poverty have made them vulnerable to traumatic injury. I should say, when I presented an earlier version of this piece to the Fordham Law faculty, this is where everybody was pointing. There's the, Martha, you have to acknowledge this is a big leap from IIAD to eggshell plaintiff. But I say to this group, herein lies the distinction between corrective justice and social justice theories of tort law. If one of the aims of tort law is to rectify or ameliorate unjustified social inequalities, as social justice torts theorists contend, using trauma in both contexts makes sense. After all, baked into the concept of trauma is an appreciation of the harms of domination and oppression, systematic social structures that affect large groups of subordinated peoples. Although these systems of oppression lurk in the background when an individual rape victim sues for a battery, or a person of color claims injury from a racist insult, those systems are nevertheless present, making the victim an easy target, vulnerable to injury, not unlike the woman in the donut shop is vulnerable to injury, not unlike the eggshell plaintiff who can expect to suffer exacerbated injury if exposed to future trauma. One additional legal obstacle, of course, facing application of the eggshell plaintiff rule in the racial trauma context is, however, once again, the penchant of courts to characterize trauma as pure emotional distress rather than a distinctive traumatic injury, which I'm trying to push here, and to apply more stringent rules. The third restatement of torts, for example, takes the position, this is a tiny little, sub-doctrine, takes the position that if the ultimate harm caused by an eggshell plaintiff is pure emotional harm rather than physical harm, recovery will be permitted, this intensified augmented recovery will be permitted only when a person of ordinary sensibilities in the same circumstances would suffer severe harm. In other words, the eggshell plaintiff rule is blunted right there by the physical emotional distinction. And enhanced recovery is only allowed if people who had never suffered trauma would also suffer severe emotional distress under the circumstances. I like to change that. So the third context, and this is different, but I think illuminating, in which trauma plays a significant role, involves the experiences of people giving birth. The focus here is on birth trauma arising from what's known as obstetric mistreatment or obstetric violence, referring to abuse and mistreatment of patients during labor and childbirth at the hands of physicians, nurses, and other medical personnel. While it's difficult to capture all the behaviors that fall under the heading of obstetric mistreatment, a recent taxonomy by Elizabeth Kokora offers three major categories: abuse in childbirth, coercive treatment, and disrespect. By abuse in childbirth consists of the most serious violations, including forced surgeries like unconsented to cesarean sections or episiotomies, other unconsented to medical procedures, including inducing labor. I've been reading cases in which the physician breaks a woman's water without her consent, or the use of restraints to limit the ability of a person in labor to change positions or to move. Falling under the coercive treatment category are various tactics used when a patient declines to follow medical advice, including threats to get a court order or to call in child welfare authorities or to withhold pain medication or other treatment. Finally, disrespect consists of patronizing and disparaging comments, including being yelled at, ignored, or accused of being selfish. To get a sense of the magnitude of the problem in the United States, one large study indicated that 28.1% of individuals giving birth in US hospitals experienced mistreatment by providers during labor. And not surprisingly, the rates were higher for women of color. That's a big number. So birth trauma arising from obstetric violence is an example, I would say a quintessential example of an intersectional harm that implicates at least race and gender. Paternalism still characterizes the doctor-patient relationship in the context of childbirth. The doctrine of informed consent here seems to get distorted because of what's known as the two patients rule, requiring the physician simultaneously to treat the person giving birth and the fetus. As tort law has developed, physicians have far greater incentive to protect the fetus, largely because of huge damage awards for harms to the fetus, but few awards to those persons giving birth. And it's only going to be exacerbated by the Dobbs decision overruling Roe versus Wade in the United States. Low-income women and women of color are disproportionately subjected to coercive tactics in childbirth, such as threats to call in child welfare. And Black women have very high rates of unnecessary C-sections with their emotional health risks, with their associated health risks. This theorization of obstetric violence as an intersectional harm, of course, ties it to the systems of sexual and racial subordination related to rape trauma and racial trauma, but like other intersectional harms, affects childbearing persons in distinctive ways that are not just a sum of mistreatment based on race and sex. So these concerns were crystallized in Serena Williams' account of her childbirth trauma. Williams didn't undergo an unnecessary C-section. Instead, her complaints centered on the care she received after the C-section was performed. While recovering in the hospital, Williams felt short of breath, and she urged her medical team to perform a CT scan and administer IV heparin, a blood thinner, given her history of blood clots. The nurse refused, believing that Williams was confused because of the pain medication she was taking. The doctors also delayed before finally acceding to Williams's plea for a CT scan. Then they discovered several small blood clots in her lungs. Additional serious complications developed, requiring more surgery. Going public with her story, Williams described how she felt depressed for months after the birth, with feelings of anger, guilt, and sadness. Serena Williams' story has really resonated, particularly with women of color. Perhaps most telling was the reluctance of medical personnel to credit Williams' account of what she was experiencing in her own body, given her status as a preeminent athlete. So it's important to recognize that birth trauma overlaps with PTSD, but the two are not identical. Here, it's not a problem with criteria A, like it is in the racial trauma context, because labor and delivery are likely to qualify as stressors under criteria A, because individuals giving birth are threatened with death or serious injury, and because they often witness firsthand their newborn's distress. But the research indicates that only between 3 and 4% of people who have suffered symptoms are able to get a PTSD diagnosis. The disparity between the 3.4% figure and the 28% figure who report being traumatized by childbirth from the literature I could read is explained by a finding that although a substantial number of them suffer from the symptoms and their clinically significant PTSD symptoms, they nevertheless remain below the diagnostic threshold. So not having the full constellation of mandatory symptoms or below the diagnostic threshold. Now, it may be that as more is written and understood about birth trauma, clinicians will begin to diagnose more cases of PTSD. There's ample research documenting that birthing persons experience intrusive symptoms, including perceiving the caregiver role for their newborns as a reminder of the traumatic birth event. Particularly birthing persons with a history of sexual assault are likely to experience obstetric violence as violating and as a trigger for their for re-experiencing the prior assault. Finally, accounts of postpartum difficulties that mothers face caring for their newborns, including depression, feeling of inadequacy, panic, anxiety, guilt, are familiar, although they may be not often diagnosed as negative alterations in cognition and mood, or alterations in arousal and reactivity that you need for a PTSD diagnosis. However, even if birth trauma does not qualify as PTSD under the current standards, I think the medical evidence indicates that it's a real, widespread, and serious injury, and counsels that trauma traceable to obstetric violence and mistreatment should find a remedy in tort law. So thank you for bearing with me. And now the 3 lessons. So I think trauma makes it obvious that it's futile to insist on a rigid classification of injury as either physical or emotional. More so than other injuries, trauma lies at the intersection of the physical and emotional. Alleging that a plaintiff's symptoms track at least some of the classic PTSD symptoms should go a long way towards proving the severity of the injury, however we want to classify it. Now, one can imagine providing generous recovery for tort victims in these contexts while still classifying the trauma as purely emotional or dignitary harm. But treating trauma as a distinctive injury, I think, can work against the minimization of the harm, and it has the great benefit of echoing the language of victims who have experienced the harm. The second lesson, as I studied trauma, it really exposes the truth that most of us, many of us individuals, are vulnerable. And tort law should not ignore those vulnerabilities. As Martha Feynman has famously maintained, all individuals are vulnerable in the sense that they're in a constant state of possible harm from injury, catastrophe, or misfortune, and are always at risk of becoming dependent from disease, natural disasters, or economic or institutional crises. In my view, the venerable eggshell plaintiff rule is not just a quirky rule about proximate cause or damages. Instead, the eggshell plaintiff doctrine represents an ideal of individual and relational justice, requiring a response that fits the needs of the particular victim, vulnerabilities, and all. Once the widespread incidence of trauma is revealed, the invocation to take the plaintiff as you find him or her takes on a new meaning. It can be seen as a fundamental principle that sets the basic terms of human interaction, and as Hannah Davgad and Avihai Dorfman have argued, requires actors to take account of others' relevant personal qualities, including their distinctive characteristics and circumstances. And for those instrumentalist types, reinvigorating the eggshell plaintiff rule would require defendants to internalize more of the costs of injuring vulnerable persons, no longer allowing them to assume that low-income minority or marginalized victims will automatically translate into lower recoveries. Finally, trauma in the damage it inflicts is, of course, more readily apparent through a social justice lens. It's no coincidence that the idea of trauma plays a central role in contemporary social justice movements, and that the three contexts of trauma I have discussed only became visible in part because of such social movements. A social justice approach encourages us to untangle the systemic violence woven into the rules and remedy of tort law, and can point us towards ameliorating doctrines that connect to people's lives in concrete ways that take account of, rather than bracket out, the social context surrounding their injuries. One tenet of social justice tort theory is that the compensatory ideal of tort law, the notion of making persons whole, can't be extricated from the social inequalities and systemic forms of injustice in the larger society. Although trauma affects individuals in individualized ways, we can only grasp its full force if we see the larger picture, whether we're a Vietnam vet, a rape survivor, a target of racial attacks, or a person giving birth in a maternity. Recurring injuries that disproportionately affect marginalized groups have not been prioritized in the law of torts. And that's an understatement. But I think they could be elevated through recognition of trauma damages. Thank you for sticking with me.
Thank you so much, Martha, for that really interesting talk on a very interesting and important subject. So what I'll do now is we have about half an hour for a discussion, which I'm sure will be very lively. I see a few hands up. I think I'll begin with those hands and sort of take a cue, starting with Stephen Patel is the first one that I saw. Otherwise, I think an easy way to get on the queue is to send me a direct message with like a question mark or saying that you have a question, and I'll take a cue from there. But first, starting with Professor Patel.
Thank you. Martha, thanks for the talk. Great to see you again. I apologize. Western schedules its Senate meetings for 1:30 on a Friday afternoon, and our law faculty in its wisdom has put most of its tort people on Senate. So a bunch of us are going to have to disappear to Senate. So I wanted to try to get a question in before having to leave. And it's this. So when I try to think about this distinction between an eggshell personality and a kind of crumbling skull personality, I start to worry about sort of marginalized groups and this idea that sort of you've lived and grown up in these very difficult conditions. And we say, this is what's hard for me. I mean, do we say that that's an eggshell type person? Because I think about eggshells as the idea that, but for the tort, this wouldn't have manifested, right? So the reason the defendant has to pay for it is because the eggshell condition otherwise never would have manifested. Whereas the crumbling condition, we think, is one that might well indeed have otherwise manifested later on down the line. And so it's not right to make the defendant responsible for it. And so I wonder in some of these cases whether that might be a very difficult line to draw in cases of sort of historic lived experience that has got you to a kind of state where you're carrying around sort of the sort of weight of the world idea, all these microaggressions, all these difficulties that are happening to me. I'm wondering whether we would think that that's a crumbling skull or a eggshell skull. And in particular, I kind of, when you then said, well, you can have this train derailment near a sort of marginalized community, I mean, that's really what kind of got me thinking about that, right? I mean, do we say, well, that's a whole community of eggshell personalities, or do we say, no, hang on, that's a historic whole community of crumbling personalities? And I think the distinction obviously affects damages, right?
So thank you. And, I haven't really in my mind thought of the difference between eggshell and crumbling. I don't think eggshell plaintiff, if I could come up with a term, would be the term that I would use. The reason that I'm latching onto it is because it's so traditional. So really, it's a pre-existing vulnerability. And so sometimes it will manifest itself even if there isn't this singular tortious event, but the event precipitates it. What we, I think, can say with more certainty is that the person may suffer an intensified injury because of their pre-existing vulnerability. So, and what I think one would have to envision these lawsuits, and this is what's hard. So the best article about widespread lawsuits and use of trauma is an article written by Angela and Wache Willig. And she talked about how trauma was used, and interestingly enough, a lawsuit involving educational discrimination. And it was aimed at getting the school to adopt trauma-informed disciplinary procedures and otherwise to have their curriculum respond to the population of children that they were serving. So they had to kind of figure out a way to get trauma into an anti-discrimination lawsuit. And when you have a class action, it may be doing a sort of trauma study of the population. If you have an individual victim, it may be getting a diagnosis of this complex trauma that I talked about. So it seems to me that, I'm not saying that this can be easily adapted the way our RBTS could be put into an intentional infliction suit. But it does seem to me that rather than having this unthinking acceptance that injuries that occur in low-income neighborhoods cause fewer damages, we ought to flip that and say we are dealing with vulnerable populations. And if indeed there is a basis for legal liability, we ought to investigate the need for trauma counseling, the need for mental health services, and the possibility, the great possibility, that many of the people affected, because they are vulnerable, will need more rather than less compensation. Admittedly, not so finely grained.
Sophia, I believe you had a question on this point. Similar.
Thanks. Yeah, thanks, Martha. My question was also about the crumbling skull doctrine, because I've been thinking a lot about that, as have other Canadians, in light of our residential school litigation, where this came up, and in a context in which plaintiffs had suffered from severe trauma. Our litigation didn't often use the language of trauma, but these were Indigenous children who had lived in homes characterized by extreme poverty and deprivation because of a legacy of racism and colonialism, essentially were suffering from trauma, and then were forcibly removed and sent to schools where they were further subject to actually emotional and physical abuse and sexual abuse. And in one of our famous cases, Blackwater and Plint, the trial judge held that a plaintiff in these circumstances was essentially already in a damaged condition prior to coming to the school and suffering sexual abuse, and that damage needed to be deducted from the damage award. So applied the crumbling skull rule in that way. So I'm wondering actually whether your remarks on trauma and the way in which social justice is implicated in trauma actually do suggest, if pushed in this direction, that maybe we need in certain respects to think about actually revising the crumbling skull rule in these sorts of cases where the trauma is due to certain kinds of social injustice. That of course raises difficult questions. In this kind of case, the residential schools case, I'm wondering if you might say, look, there ordinarily maybe it wouldn't be fair to defendants to hold them responsible for a plaintiff's already damaged condition, but in a case where the defendant is a public authority charged with ensuring and maintaining things like social justice, maybe that unfairness is mitigated or just drops out of the picture and we need to revise the crumbling skull doctrine. I'm wondering if you have any thoughts on any of that.
Oh, okay. So I think in terms of the doctrine, it's really interesting where we locate the eggshell or crumbling skull doctrine. I think of it as of proximate cause. But I think it should be distinguished from causation and fact. So if the claim is that the individual would not have that the defendant's conduct didn't play a role in the individual suffering the harm when they did, then of course there's no cause and fact. The way the Canadian court seems to be looking at the crumbling skull is a rule of damages. And, that's a little different. And there's really two ways that you can look at it. You could say you take the plaintiff as you find them. So you should have to pay more than you might ordinarily expect. Or you can kind of say, well, let's try to parse out the slice of the damage done by the defendant's tortious act. So that's the kind of really basic sort of rethinking that I think is it damages. Why do I say proximate cause? Because I think once you prove causation and fact, which is probably going to be easy because of timing and the nature of these claims, particularly if you have an event like a train derailment or something like that, then I have always thought about proximate cause as a proximate cause rule, meaning that we are not going to say these damages are unforeseeable and not allow recovery like the Wagon Mound court did. But because we recognize that communities are made up of people who have different kinds of vulnerabilities, and this is where, the social justice or like the relational justice approaches really come into account. We should consider this to be a rule that says we will, perhaps as a matter of social policy, find that there is proximate cause. And if you want to limit damages, there are other ways to do it, which of course we always find. But, as I say, this is just a real preliminary cut. And I have to begin to think about the sort of what I would call erosion of the eggshell plaintiff rule that's already taken place.
Great. Next on the list, Professor Sashi Karen Paz.
Great, thank you. Thank you for Martha. It's been lovely to hear you, and I really enjoyed the previous comments. So I have 2 or 3 comments about the eggshell skull, and one about one of your lessons. So in terms of you mentioned, the similarity, with risking the poor, yeah. So obviously I sympathize with with your logic. I argue it myself in my 2007 book and in the 2003 article. Also, that so there are 2 aspects here. First, the idea is to think not as law and economics we think, in absolute amount of money, but in terms of utility and diminishing marginal utility of money. So if you risk those who have less, so you caused a bigger loss of utility, so that could be justification, for compensation. Second, and relatedly, it was very interesting discussion of, where to locate it as a rule of damages, as a rule of proximate cause, factual causation. But there's also the issue of standard, although again, obviously, depend on the context. And it also relates to our real Parat's work on misalignments, whether we treat things differently in when we set a standard as opposed to how much we compensate. But it's obviously relevant and relates to the issue of utility. And the third point about that is that I think there's also a difference whether the previous condition is tortious or not. Because we could think of it, if, for example, there were 2, racial slurs, at different times, and the combination of them is what caused the trauma. So arguably, both of them should be liable according to regular rules of causation. And here, obviously, it gets tricky, between background conditions and specific instances of discrimination or abuse or something like that. So that's the set of comments about the eggshell skull. Then in your when you were discussing the lessons, so what I took from your first lesson is sort of the priority of the symptoms over the causes, that if there is a symptom, so there should be a good reason to be lenient in terms of what was the cause. And again, I'm very sympathetic to that. So I haven't written on this, and it's been some time since I was teaching undergraduates about psychiatric injury. But it always struck me that the rules, for example, in the UK and in other countries, for secondary victims, don't make much sense. The ties of love and affection, because I would give my student the example. Let's say that I'm such a terrific teacher that some of you would get psychiatric injury if I get run over. So I'm saying it's not very likely, yeah. But if it does happen, why? The fact that I'm not a spouse, a child, or a parent should really matter if it did bring these results. So again, I sympathize with the prioritization of the symptoms over, the initial cause. Thank you.
Thanks so much. First of all, as you readily recognized, your scholarship very much influenced me when I thought, what can I say about the eggshell plaintiff? Because when you discussed, how we ought to deal with the hand formula and the sort of looking at the risk utility standard with an eye toward social justice, how it looks so very different. So one thing that is so basic, but let me just say it. Once you start taking a social justice lens, like, feminists thought of in the 1980s, all the building blocks of tort start looking different. And in order to make any one of them make sense, it's nice if the other building blocks reinforce it. So, to just say, okay, let's put this idea of the vulnerable eggshell plaintiff into a social justice frame in our current legal landscape is kind of ill-fitting. In fact, it's even hard to conceptualize the kind of lawsuit that might raise it. And I think it's interesting that you say, the residential children litigation, because of course, that's pretty much what Angela Willig used when in her investigation of trauma in law, because we think so much of, the childhood population. That. So I just want to underscore that I see the difficulty, and one minor, or at least I should say more specific problem, is that unlike in situations where you have a person who's been sexually victimized and then becomes a victim by cyber violence or something like that, where you can kind of pinpoint two different times and maybe have two different perpetrators. And the question becomes, how much should each perpetrator pay, like your recent book spends so much time delineating. This is obviously different because most of the, particularly when it comes to kids, you know that they've been traumatized, but it's very hard to get at the source. Often it's not just extreme poverty, but violence of a caregiver. But the kids don't talk, and so it is very difficult. We have to find a way of somehow identifying that and at least responding compassionately when we're dealing with litigation affecting these populations. And it's quite the challenge. And I think for now, the intervention that I wanted to make is using the term trauma in tort law, as basic as it seems, is probably a good move, rather than somehow thinking that our current vocabulary, mainstream vocabulary of tort law, is adequate. So you put your finger on it, the symptoms more important than criteria A. Absolutely the case in birth trauma. I mean, when I started looking at birth trauma, I thought, hey, this is something that we really we should see more lawsuits. We should, we're going to see insurance in these lawsuits because they're malpractice claims. We should see, what this is really having no vocabulary before. I think the racial trauma stuff is more difficult because If you say, we're not going to worry about criteria A, it can be microaggressions, then you have to decide what constellation of symptoms, and then whether it will require medical proof, because usually you need a psychiatrist or you need some kind of medical proof. So it's just a very modest recommendation, but it seems to be that we should start talking about traumatic damages and torts. And we should look at that mandatory list of symptoms as a pretty good preliminary guide to when there's been some kind of traumatic damage. We don't have to call it PTSD. And if we call it traumatic damage, let's not use all the restrictive rules for emotional distress. Now, that won't nearly get us to the large populations receiving mental health care or anything else, even within the realm of tort, but it's not nothing. And it's amazing that we haven't done that much in tort so far.
Thanks. Next, I have Professor Raki Ruparelia.
Great. Thank you so much. And I apologize for not having a working video on my computer. So please bear with me. I hope everybody can hear me okay. Thank you so much for that really interesting talk. And it aligns really well with some of the things that I've been thinking about in my own work, both in torts and in critical race theory more generally, where I've been looking at, I've been looking more and more around racial trauma and how what kind of roles it plays in different contexts in law, torts, and in criminal law and other places as well. So I've been thinking there's so many great questions that have come up. So now I'm having even more probably disconnected thoughts to my previous questions. But I'm wondering, because a lot of what you were talking about was about like sort of with the intentional infliction of emotional distress and that being a lead up to traumatic consequences. I'm wondering what you think would be the role of negligence in this, because I'm thinking like there were so many contexts where even with the obstetrical cases where it may not be, outright abusive conduct or even intended to be disrespectful conduct, but where negligence that actually may in fact be racially, there may be a racial overtone or undertone or whatever to that negligence as well. Like how would that change anything about how we're looking at this in terms of it possibly could lead to the exact same trauma, right? Whether it's PTSD or any other kind of trauma. And I was also thinking about the evidentiary burdens and, what kind of difficulties we might have. Because especially with racial trauma, like some of the examples of having, if someone says a racial slur, it's much easier to identify that as racist, right? For the purposes of even a race-based trauma. But where we're talking about sort of the more subconscious or day-to-day racial microaggressions, where would that fit into this? And can we still, like when we talk about chronic kind of racial trauma or trauma that people experience over a lifetime because of this kind of daily assault of microaggressions, like does that have a place in this kind of framework, or do we really need to kind of hang it on something that's more intentional, I guess, or more like that's sort of, well, it's just more deliberate as far as like intending some kind of consequence, or should have, something that we should anticipate. And, when we're trying to, I guess the other part of that is, with the example I was giving before with the obstetrical cases where, we're talking about how, and you said in the States, and it's the same here with women of color having more incidents of, both, I would say, intentional and malpractice in terms of negligence, cases where, whether it's their own well-being or that of the fetus has been compromised because of stereotypical beliefs or just, otherwise maybe even more subconscious behavior on the part of doctors or nurses that's resulted in injury to the fetus or to the mother or both. where there is a racial element to that, is there room to kind of bring in both of these, right? Or is it something that we're going to end up compartmentalizing because it's too complicated? So we're kind of thinking of it in separate realms. And again, do we get into the issues of how do we prove it too? So I know there's a lot in there, but there are just some things that I was thinking about when you're speaking, because it's such a fascinating area. So thank you again for that.
So I want to thank you so much for your comments, because a light bulb went off here. And I realized I hadn't made it explicit, and maybe not even in my own mind, but negligence can cause trauma. Because I think people think about trauma as involving only the result of intentional acts. And particularly in the birth trauma context, but in the article that I wrote with Jonathan Carty, A Negligence Claim for Rape, our whole point was that there are instances of sexual abuse that should be at least considered under a negligence framework that do every bit as much harm as what we currently think of as intentional rapes. So what might that mean if we say negligence can cause trauma? Well, I think what I'm thinking about is, if trauma is something that straddles the line between the physical and the emotional, all right? You know that what I'm really saying is it should be assimilated to the physical. The body keeps the score. I should probably be more that it should be upgraded, that you have a more, and for someone who has wanted to upgrade emotional harm, just dismantle the distinction. Let me just play with this and say, if trauma is thought of as a distinctive injury that could be assimilated to physical harm, when you have documented obstetric mistreatment that we can call malpractice, because we can think of it as medical negligence, either in not adequately honoring informed consent, or acting in ways that produce, like, an unconsented to procedure, or any of these forms, then I think that does help us move this sort of newish malpractice claim along. And, I would say it also helps in the rape context. What's the most difficult to theorize is this kind of chronic racism, and where that plays in, how that plays into recovery. And I think that if we begin to get a bit more understanding of race-based traumatic stress, even in the classic individual cases, I kind of think that's going to help us in the deal with the sort of larger population, non-explicitly racist kinds of train derailment in a low-income neighborhood case, because we'll begin to understand how these kinds of injuries manifest themselves in similar populations.
Thanks. I think
Thanks so much for that.
Thank you. I think we have time for one final question from Professor Rebecca Cook.
Thank you, Martha, for this very illuminating talk. I'm wondering whether there's any trend in the US to move from obstetric abuse to gynecological abuse. I don't know I'm not on top of the details in the US jurisprudence, but certainly comparative law, there's a whole slew of cases where women seeking a test to determine whether they want to have an abortion have been denied. And in your Serena Williams case, she was denied appropriate tests. And in the article that you cite, Elizabeth Kosera, is that the name?
Kukura.
Cora,
K-U-R-A.
K-U-R-A. She talks about one of the three that you outline is coercive treatment, and I'm wondering if that's including denial of appropriate treatment of the standard of care.
So Kakura's article, which is wonderful, kind of brackets childbirth, just because it's already a big topic. But what I love about that article is that her taxonomy is not one, it's not a legal taxonomy. It's what birthing persons have experienced. And so certainly what you mentioned as gynecological abuse could, I think, form part of that. The critical boundary, I believe, here is that it's treatment that not only is largely confined to women, but in this sort of hyper fraught area of reproduction and childbirth. And this is why I know that we need to do so much more of this, and just sort of looking at the three social movements, Me Too, Black Lives Matters, reproductive justice, and just saying, okay, this is what we need to bring into tort law. So from what I've seen, there aren't that many US cases, and the ones that you get are just the horrific cases of someone who, didn't want a C-section because they wanted to have multiple births, and it'd be harder if they had a C-section. The doctor just blew them off. I mean, they're very, very extreme cases. So with respect to, I think, reproductive justice, we're at a very low level. And interestingly enough, just to think about what's the template, it's so interesting. It's not race, it's rape. Rape is sort of the prototypical injury, and we can kind of learn about things. And then reproductive injuries and racist injuries from racism and discrimination. We're sort of assimilating to rape. So we need to do a lot more in just identifying, categorizing, label these as medical malpractice. What I'm hoping is that even though judges, when they instruct, say, don't use the fact of trauma to prove that the incident actually happened, it's not substantive law, the trauma is more on the damages end here. It goes a long way towards proving that the incident really happened. And we know that from rape victims, that they can use the PTSD diagnosis to say, I didn't consent. I would not have suffered trauma if I had consented. So I think we're going to, that's why I think there's a lot to be, there's a lot useful here. And that's why I'm looking at trauma, a construct that I've not really used, even after writing about all that mental distress stuff for so long.
Well, thanks, Martha, and sorry to cut short a very lively discussion, but we're out of time. Thank you so much for giving us that glimpse into how the world of tort looks through a social justice lens, to use the metaphor you provided. That was great. And thanks to everybody for making this such an excellent first session of the speaker series. We're looking forward to the next one next month from Sandra Sperino, one of Martha's previous collaborators. And we hope you can all join us again for that. And I'll offer any potential last words from Sophia as well. But otherwise, I think we're all set. Thank you, Martha. Appreciate it. And thank you, everybody else, for coming.
Thank you all so much.
Take care.
Thank you.
Bye.
Thanks so much, Martha. That was terrific. Really, really wonderful. We appreciate it.
Thank you.